attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the recommendations of the SEC Government Business Forum on small business capital formation, a forum I had the honor of participating in and attending. Over the last few LawCasts in this series, I have been going over the 15 recommendations of the forum in their order of priority. Today, I am starting with the 9th recommendation and completing my summary. The 9th recommendation is that the eligibility requirements for the use of Form S-3 should be revised to include all reporting companies. The 10th recommendation is that the SEC should clarify the relationship of exempt offerings in which general solicitation is not permitted, such as in Section 4A2 and Rule 506B offerings, with Rule 506C offerings involving general solicitation in the following ways. 1. The facts and circumstances analysis regarding whether general solicitation is attributable to purchasers in an exempt offering should apply equally to offerings that allow general solicitation as to those that do not, such that even if an offering is labeled 506C, if in fact no general solicitation is used, it can be treated as a 506B offering. And second, to clarify that Rule 152 applies to Rule 506C, so that an issuer using Rule 506C may subsequently engage in a registered public offering without adversely affecting the Rule 506C exemption. I note that within days of the forum, the SEC did indeed issue guidance on the use of Rule 152 as applies to Rule 506C offerings, at least as relates to an integration analysis between 506B and 506C offerings. The 11th recommendation is that the SEC should amend Regulation ATS to allow for the resale of unregistered securities, including those traded pursuant to Rule 144 and 144A and issued pursuant to Section 4A2, Section 4A6, and 4A7, and Rules 504 and 506. The 12th recommendation is that the SEC should permit an ATS to file a 15C211 with FINRA and review the FINRA process to make sure that there is no undue burden on applicants and issuers. An ATS is an alternative trading system. The OTC Markets platform is an ATS, so the recommendation would allow OTC Markets itself to file a 15C211 application on behalf of an issuer. A 15C211 application is the application submitted to FINRA to obtain a trading symbol and allow market makers to quote the securities of companies that trade on an ATS, such as the OTC markets. Today, only market makers seeking to quote the trading in securities can submit the application. Also, today, the application process can be very difficult, and there is a lack of clear guidance or timelines for the market makers and companies involved. This process definitely needs attention, and this recommendation would be an excellent start. The 13th recommendation is that Regulation CF should be amended to permit the usage of special purpose vehicles so that many small investors may be grouped together into one entity, which then makes a single investment in a company raising capital under Regulation CF. As a reminder, Regulation CF is regulation crowdfunding. And 2, to harmonize the Regulation CF advertising rules to avoid traps in situations where an issuer advertises or engages in general solicitation under Regulation A or Rule 506C and then converts to or from a Regulation CF offering. The 14th recommendation is that the SEC should provide greater clarity on when trading activities require ATS registration and when an entity or technology platform needs to be a funding portal, broker-dealer, ATS, and/or exchange in order to be engaged in the business of secondary trading transactions. The last recommendation, and I love this one, is to reduce the Rule 144 holding period to 3 months for reporting companies. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.